Hello everyone, welcome back once again to StudyIQ English, your favorite channel. And I am your educator, Praveen Mishra. And let's proceed with today's topic, today's session that is continuing the series of Indian polity. And we were on the chapter that is fundamental rights. So in the previous session, that is in the previous class, we discussed till Article 28. That is about freedom as to attendance of religious instructions in the educational institutions. So what we have seen, that has divided the educational institutions into 4 different subheads. Okay, and continuing the articles, we have got the next one into the picture, that is Article 29, protection of interests of minorities. Okay, what is that? Protection of interests of what? Minorities. So first of all, the minority word is something which is always subject of too much debate. That who is a minority? Yes, the one who is less in population is minority. But as I told you in the very first, the second class, while we were starting the fundamental rights segment, that make it very clear that from today onwards, you have got distinct meanings. One is the general meaning of any single English word, and the other is the meaning that is justified by the Constitution, okay, or things that are according to that word identified by the Constitution, right? So obviously, yes, when it comes to the general terms, minority, that is the ones, those who are lesser in number as compared to the other population, okay, that is the one, those who are in the edge effect. Now coming to the next one, constitutionally, who is a minority? So the Constitution of India identifies only two types of minorities. Okay, be very specific. The Constitution identifies only 2 types of minorities and not beyond that. What are these 2 types of minorities? They are firstly the religious minorities. Okay. And secondly, they are not the caste, custom, color, creed based, but yes, they are based on language, that is linguistic minorities. Okay, so they are 2 types. There are 2 types of minorities only as justified by the Constitution. There doesn't exist any third type of minority. Okay, what are they? Religious minorities as well as linguistic minorities. 1 and 2. That's it. Does there exist any third type of minority? No, it doesn't. There is nothing known as third sphere of minorities according to the Constitution, right? So now Article 29, protection of interests of minorities. Which minorities? Obviously religious as well as linguistic. That's it. Okay. So it ensures, what does it focuses on? It ensures the rights of minorities to preserve and promote their language, script, and culture. So what are the things? Whatever your language is as a minority, your script, your culture, your customs, traditions, beliefs, faith, etc. And it also prohibits discrimination against any citizen for admission into educational institutions funded by the state. Okay, this is also what we have discussed during discussing Article 15, right? Okay, so Article 29, protection of the interests of the minorities. Who are the minorities? Only 2 types. Okay, the first is religious, second one is linguistic. Does there exist any third? Absolutely not. Okay, so protection of the interest of minorities, that is each and every minority group in India, they have got the right to preserve and protect the language, custom, traditions, script, faith, belief, worship of their own, according to their own customs. No one will be there coming and interfering in between, do like this, do like that. No one will come. Okay, next, with the same Article 29 itself, that is Article 30, the right of minorities to establish and administer their own educational institutions. Okay, it is the right of each and every minority. Okay, that is, they do possess the right to establish and administer their own educational institutions. They can establish by themselves, and their administration will also be centered in the hands of that particular minority group only. Okay, so rights of minorities to establish. Let's say I'm a minority coming from any religion or a language. I want to establish my XYZ school, XYZ college, or an XYZ university. Then can I? Yes. Who can establish? I can establish. Who will administer it? Will the state come in between? No. Even if the state come in between, then also the administration of the organization or the institution will be centered in my hands only. Okay. So it provides for grants religious and linguistic minorities the right to establish and manage their educational institutions, and provides autonomy to minority institutions while ensuring they follow broader educational standards. So all those minority educational institutions will be having the proper autonomy. Just the condition is their education standard should be at the par level. Okay, it should be maintaining a minimum amount of bar. Okay, that is what Article 30, that is right of minorities to establish and administer their own educational institutions. Next comes Article 32. And now you would be thinking, sir, 30, 32, no, 31, where it is? It is nowhere. RIP, rest in peace. Okay, it's nowhere in picture, it's nowhere in action. It has been repealed by the 44th Constitutional Amendment Act. So as what we can talk about, Article 31. It was there as right to property. It was. It is not. Okay. It is repealed. Okay. It is what? It is now repealed. Repealed through what? Repealed through the 44th Constitutional Amendment Act. Which year? 1978. Repealed as in, what is the meaning of the word repealed? Simply, no longer in use or action. Right? That's it. Now, there are other articles as well. Okay, so there are certain other articles as well. But I suggest you guys not to read those articles for now. Skip them for now. We will discuss them, don't worry. After completing some certain chapters. Let's say after completing the powers of the union and the state, including the president and the governors. And apart from that, also understanding Schedule 5 and Schedule 6. Then we will come back to fundamental rights segment again. The articles that we are skipping for now, that is Article 31 capital A. Okay, we are skipping for now. We are not reading it. Next is Article 31 capital B. And next is Article 31 capital C. So guys, make it clear. It's not like that we won't discuss them. We will discuss them. But the only concern is after completing some certain chapters. Let's say the administration of scheduled and tribal areas. Okay. The center-state relations. And apart from that, the powers of the president, governors, along with the other bodies of the union as well as the state. Then only we will come back to these particular articles. As in, because if we read them right now, it will be a grave confusion here. It might also demoralize that, arey yaar, ye to bahut tough cheez hai. It's very difficult thing, man. No. Right? So let's be very, specific, and let's be very relaxed and be very simple. We won't make things complex. We won't just, make the complex structures here. Okay, let the things be as simple as possible. So letting things being simple, okay, Article 31, capital A, capital B, and capital C, they are to be discussed after completing some certain chapters. Okay, so don't worry. We will discuss them. We'll come back to these topics. So now coming to Article 32. As what the great personality, Dr. Bhimrao Ambedkar Sahab has called. That this article is the heart and soul of the Constitution. As you can see, the statement has come from none other than Dr. Bhimrao Ambedkar. Okay, as it provides you the direct opportunity, an opportunity to directly appeal to the Honorable Supreme Court of India, that is the apex court of the nation, to restore or reapply your fundamental rights in case they have been infringed or violated, right? So what is the hierarchy? Okay, let's say there is any general case, okay. So with regard to any general case, first door that you can knock for justice or appeal or petition or litigation, whatever, it is the lower courts. We call them as subordinate courts. They are available near your home, in your district. Any judgment that has been passed by subordinate courts, and let's say you aren't happy with the judgment, then you have the authority or the right to challenge the judgment passed by the subordinate court to the High Court of your state. Okay. And let's say the judgment has been passed by the High Court as well, and still you are not satisfied. Still you believe that no, still this is not the justice to me. Then you have the authority or the right again to appeal the judgment of the High Court to the last resort of appeal, that is the Supreme Court of India, right? But as mentioned, this is all for what? This is all for general cases, that you have to start from the bottommost line, bottommost organ, that is the subordinate courts. Let's reverse the story, okay, or change the story actually. If it is the case of violation of my fundamental rights, in case my fundamental rights, they have been violated or abridged or infringed whatsoever, then once again there is subordinate courts, but skip them, okay, skip the subordinate court section. Then above that, what we have got? High courts. So skip the high courts as well. You can bypass these two hierarchies, okay, these two bodies, and directly knock the doors of the Supreme Court. Under which article? Under Article 32. You can directly knock the doors of Supreme Court. That knock, knock, it's me and my fundamental rights, they have been infringed. Please do me the favor, do the needful. Reassure me my fundamental rights. In case, okay, you feel, okay, Supreme Court, no, I do not want to appeal to the Supreme Court and want to just appeal to the high courts, then also you have got this authority. If you do not want to reach directly to Supreme Court, up to you, you can directly, but let's say you don't want to, okay. So under Article 226, under Article 226, okay, you can just bypass the subordinate courts and directly reach the high courts, right? Okay, so it's totally up to you whether you want to use or utilize your Article 226 or your Article 32. Whatever you are comfortable with, you have got both the options with yourself, in case any of your fundamental rights, they have been violated. Okay, so Article 32 has been given two different headings. Okay, it is given right to constitutional remedies. Okay, it is just one name, that is right to constitutional remedies. Okay, and also it is termed as the writ jurisdiction of the Supreme Court. Okay, what? The writ, this is visible, right? Yeah, writ jurisdiction of the Honorable Supreme Court of India. Right? What is the name? What is the term actually? The heart and soul of the Indian Constitution. By whom? By great Dr. B.R. Ambedkar. Right? Okay. So constitutional remedies as well as the other name writ jurisdiction. So using Article 32, Supreme Court can issue 5 types of writs. Okay, Supreme Court can issue what? 5 types of writs. The first such being the habeas corpus, a Latin term once again, which in literal terms it is having a meaning. Okay, in literal terms it is having a meaning. Habeas corpus. To habeas corpus meaning, okay, in English, to have the body of, okay, whosoever has been called. To have the body of. And habeas corpus, what it is? It ensures if the person is detained and brought before the court to examine the legality of the detention. Whosoever is detained shall be represented in front of the judicial magistrate within 24 hours of the such arrest. That is also mentioned, what we have discussed in the yesterday's session, Article 22. Right? So Article 22 says that 24 hours represent the arrested or the convicted person in front of the judicial magistrate. Right? Okay. So the very same way, habeas corpus tells that whosoever has been arrested shall be represented. Let's say, for example, where can it be used? If a person is arrested by the police, but more than 24 hours has been passed, they have been passed, okay, and still the person is not presented in front of the court, then the family members can use the right of habeas corpus, the writ of habeas corpus, and approach the judiciary, Supreme Court under Article 32, High Courts under Article 226, and the judiciary will issue the writ of habeas corpus against the police officers and ask them to represent the arrested person in front of the court. So this is what? Habeas corpus. Okay. Literal meaning, to have the body of. Next comes into the light, that is mandamus. Okay. Mandamus. What is mandamus? It is once again a Latin phrase which in English means the term we command. We command. It is issued against a government official, a public official, a public officer, a government servant basically. In case the government servant is just enjoying and not performing the duties for which he or she has been appointed for. Let's say, for example, you became IAS, Tathastu, you became, okay, IAS officer. And now, after becoming IAS or IPS or IFS or IRS, what are you doing? Enjoying, not going to office on time, just, moving here and there, enjoying that beacon light car, just posting everything on social media but not doing on the in the real world. It is hampering the administrative machinery, right? And in that case, it might happen that Supreme Court or High Courts, they might issue mandamus against you. That किस लिए कराया selection? काय को पढ़ाई किया इतना? हाँ? Why have you read so much? Why this much hard work? Why have you been selected? Why have you been appointed here? हाँ? To enjoy? No. Literally not. Okay? Work. Or if you don't want to work, then go home. Tata, bye-bye. Okay? So this is what? Mandamus. Issued against what? A public office holder. In case the public office holder is not performing his or her duty and just enjoying. Okay? So be careful. Huh? काम करना पड़ेगा. Next. Prohibition. It is issued against the lower court by the upper courts. In case the lower courts, they are violating their areas of limits, breaching their areas or their boundaries. Okay, so if a lower court is hearing a case that is supposed to be under the jurisdiction of a higher court, then in that case a writ of prohibition can be issued against that lower court. So against subordinate courts, high courts can issue. against high courts or subordinate courts, only the Supreme Court can issue. That is what is known as prohibition. That is what? To stop a lower court from exceeding its areas of jurisdiction or the boundaries of jurisdiction. Next, certiorari. See, it is written certiorari, C-E-R-T-I-O-R-A-R-I. But in Latin terms, it is pronounced as certiorari. Okay. So when we talk about certiorari, it is also a Latin phrase which means we certify that, or to certify that. This is a matter which is of a serious issue. Okay, it's a serious issue, serious matter, and should be taken at a broader level of jurisdiction. So transfer this case to me. This is what the higher courts, they will say to the lower or the subordinate courts. So what happens here? It transfers a case from a lower court to a higher court for review. Okay, so if a lower court makes a decision in a case where it exceeded its jurisdiction or violated proper legal procedures, a writ of certiorari can be filed, and this allows the higher court to review the case, potentially quashing the lower court's decision if it finds any sort of error. Right? So, certiorari, simply speaking, we certify that this is the case where we think some anomalies have happened or it is of a serious matter. So, transfer this case to us. That is, the higher court is speaking to the lower courts. Next, quo warranto. Okay. So, what is this quo warranto? Right. The fifth one. By what authority? In English, it is meant as by what authority you are holding this position. So it is once again issued by the court, the higher court, asking the legality of a person holding a public office, whether to check any such discrepancies or cheating is there or not, that this particular office, like for example, though quo warranto was not issued, but you can just understand with the example of the very famous case of Pooja Kelkar. Happened last year, the lady who cheated UPSC itself. Right? So the one who was more smarter than the UPSC, a lady cheated UPSC and became IAS officer. Right, coming from general background, she acquired the certificate of, I guess, scheduled caste or scheduled tribes or something like that, having the property in crores and represented the income certificates of less than lakhs. Okay, so a lady who cheated UPSC, last year only it happened, Pooja Kelkar case it is. Right, so though quo warranto was not issued against her, as before that only she was exposed. Okay, but yes, it can be issued by the judiciary asking the legality of a person holding the office. So if someone is appointed to a public office without meeting the eligibility criteria, a writ of quo warranto can be filed to question their right to hold that position. Okay, and the court will examine if they have the legal authority to occupy the office, and if not, they may be removed as well by the judiciary. Right, so in case a person is appointed to any public office, but it is found that that person is not fit enough or qualified enough, so in that case, judiciary can issue the writ of quo warranto and asking that by what authority, that by what quo warranto, that is simply by quo warranto you are holding this public office, justify your stand, your eligibility, your legality, and in case you are unable to, then the person is said to be removed. Okay. Next comes into the list Article 33 of the Indian Constitution. The rights of our soldiers, that are those who are employed in the armed forces. The right a common man possess is not the very same rights our soldiers they do have. Right? The common man's rights, like for example, right to life, equality, or freedom of speech, expression, movement, or many of them. they could be restricted. And it is mentioned inside our constitution under Article 33. So Article 33 basically empowers the parliament to restrict, abrogate, or modify the fundamental rights of the persons involved in the armed forces. Okay, who can do that? Only and only, remember, only and only Parliament of India has got this authority, right? So the Parliament can restrict, abrogate, or simply you can write modify the rights of the persons involved in the security or the armed forces. Okay, so this is the power only with the parliament, okay, and not, literally not with the state legislatures. Okay, so you can simply just, okay, no state legislature, no other body, nothing, only the union parliament has got this power. Okay, so it allows the court martials to be excluded from writ jurisdiction of the Supreme Court and the High Courts. So Supreme Courts and the High Courts, they cannot issue writs for the sake of court martials. For some other things they can, but not when it comes to the military courts, right? So this is Article 33, the fundamental rights of all the persons, okay, in the armed forces, from army, navy, air force, to police, okay, CISF, CRPF, BSF, whatsoever, okay, they can be amended. The fundamental rights of the persons employed in the armed forces can be amended. And who has the authority? Only and only the parliament. Neither the state governments, state legislature, governor, president, no one. Okay. Next one, Article 34. Whosoever God, a deity, you worship, you have faith in, you have belief, just pray to them, that you don't encounter or witness a scenario where you read or get to know that Article 34 has been imposed in your area. That means the situations, they are deadly. The time is deadly. Okay, the bloodshed is going on. Okay, the bloodbath is going on. Okay, so whosoever God or a deity you worship, just pray to them that, oh God, oh my God, please don't ever make me witness imposition of Article 34, that is popularly known as imposition of martial law, that is military rule. Okay, martial law, that is basically speaking military rule. The term martial law has not been defined in the constitution, but basically it means the rule of military. How many times martial law or the martial rule has been imposed in India? Okay, how many times so far? Martial law, it is 0. So far, thankfully, martial law has not yet been imposed inside our Indian territory. Emergency has been imposed n number of times, along with President's rule. But yes, not even once the martial law has been imposed. Okay. What happens when the martial law is in action? The fundamental rights, they do get suspended. The local administration, they also get suspended. The local courts, they also get suspended. All the administration, judicial powers, including police powers, they are given to military. Okay, the military courts will take over the subordinate courts. The local police and administrative machineries, they will be taken over by the military administrative machineries only. Okay, and they will continue to be there till the normal law and order situation is not revivalized. It is not revived. Okay, so Supreme Court held that the declaration of martial law is not ipso facto, that is not directly related to the result in the suspension of the writ of habeas corpus. So basically speaking, even if the martial law is in action or is in force, then also, simply speaking, fundamental right to habeas corpus or the writ jurisdiction of habeas corpus cannot be suspended. Okay, so this is what the martial law is, that is Article 34. 4. Imposition of martial law, that is military rule. How many times military rule has been imposed in India so far? 0. Okay, nil. Not yet. And what happens? Fundamental rights, they do get suspended. The courts will get suspended. Local administration along with the police, they will also get suspended. Okay, and who will take over? It will be the military. Can martial law be imposed in the whole of the nation? No. Martial law can be imposed in a district or a location, that is a city or a town only. Not even the whole of the state. Okay. So this is what? Article 34, martial law, and moving to the last article of the Indian Constitution, that is of the part 3, that is fundamental rights, that is article 35. There are certain powers that are given only to Parliament with regard to the legislation of fundamental rights and not the state legislatures. Okay, so what is article 35? Power to make laws giving effect to certain fundamental rights to be vested with Parliament only and not with the state legislatures. So there are some provisions related to some fundamental rights, okay, on which only and only the Union Parliament is entitled to legislate, and not literally not the state legislatures. And what are these provisions that is mentioned here? That is, Parliament and the state legislature cannot make laws. The Parliament can, but not the state legislature, with regard to Article 16 Clause 3, 32 Clause 3, 33 and 34. Okay, so please mention them, guys, very carefully. What are the articles names? Okay, they are 16 Clause 3, 32 Clause 3, Article 33 and Article 34. Only and only what? Parliament can make law and not the state legislatures. Okay, guys. So this is articles that is related to the fundamental rights. So we have discussed from articles 12 to 35, all in depth in detail. The only articles that we haven't discussed, there are 3. That is article 31 capital A, article 31 capital B and article 31 capital C, that we shall be discussing after completing some particular chapters. Okay, guys, so that's it from my side today, and we shall start the DPSP's chapter from tomorrow onwards. Thank you so much for watching, and please do subscribe for the channel if you haven't done yet. And apart from that, wherever you wish to connect with me through the social media, you guys are free to do that. That is through Instagram. It will be Praveen Mishra _2107. Okay, so you can just search the username. And apart from that, if you wish to connect with me over the Telegram, so it will be study_with_Praveen. The channel is. Okay, so Instagram is there, Telegram is there. Wherever you guys want to connect, you guys are free to connect. Okay, everyone. So thank you so much for watching. See you all soon in the very next session. Bye bye. Good day. Take care. Jai Hind. Jai Bharat.